welcome to One on One. I am Cyril Stober. The Buhari administration had its work cut out for it when it first came on board in 2015. There were tons of impediments to national development, the economy itself, corruption, inadequate power, insecurity, unemployment, poor infrastructure, poverty. The list was long. Now, at periodic intervals, the progress of the administration came under review. It's 1 year into its second four-year tenure, 5 years so far, and today we take a look at a key part of the machinery of state, the judicial sector. My guest is the nation's chief law officer, the Honorable Attorney General of the Federation and Minister of Justice, Abubakar Malami, a senior advocate of Nigeria. Minister, thanks for being here on One on One.
Thank you, Cyril. I'm grateful for having me on board.
Right. If we just look at some of the functions, a key part of it is access to justice for all persons and the observance of the rule of law and due process by all ministries, departments, and agencies. That's just one of the many functions of this ministry. Would you say, after 5 years, that there's access to justice for all persons, and we have met this to a large extent?
Well, generally speaking, in assessing the progress and development made in the justice sector, you have to take into consideration fundamentally the various lines as it relates to the position of things when this government comes into being. Situating the baselines, you equally have to consider the key performance indicators, the targets, and then eventually what were the successes, if any, that were recorded by way of ensuring that at the end of the day, the impediments that have over time constituted a brick wall to the achievement of successes relating to the justice sector, situating them for the purpose of praising the progress made. Now, taking into consideration the baselines, for example, this is a government that inherited a situation as it relates to the access to justice, a situation whereby on account of limitation of resources, with particular reference to average Nigerians, they were not in a position to access justice. Justice, as you rightly know, is very costly, engagement of solicitors and associated things. So the government, out of concern, out of desire for access to justice, has taken a position of amending the Legal Aid Council Act, which in effect expanded the scope of the services they were expected to render. For example, before coming in place of this government, the services were restricted to criminal matters, and the scope were eventually expanded to include land matters, marriage, civil and criminal jointly. So that at the end of the day, in terms of scope, the amendment to the Act has now given an opportunity for greater access to justice. Now, over and above that, the key players in the providers of legal aid were expanded and not limited in such a way that civil societies are encouraged to partake in the provision of legal aid services, among others. So when it comes to average Nigerians that could not afford access to justice on account of their financial limitations, you can see arising from the amendments effected on the prevailing law, on the law relative to the legal aid services. We have succeeded in bringing about the desired legislation, in making the legislation work by expanding the scope and jurisdiction of the services to be provided, by making the legislation as well work in ensuring the expansion of the scope of the legal aid providers. Okay. And over and above that, The Legal Aid Council, which is saddled with the responsibility by the government of providing legal aid, was indeed further reinforced in terms of institutional capacity, in terms of the training of the lawyers that are working in the scheme, in further terms of associated access by way of ensuring that call-in centers are established across the nation, all out of sheer desire of this government to ensure at the end of the day that there are indeed access to justice.
All right. Well, what about the rule of law and due process? That's what you hear all the time. Has this administration done well in terms of due process and rule of law?
Well, in terms of due process and rule of law, I think the parameter is the fundamental consideration as far as obedience to rule of law, implementation of associated components of the rule of law are indeed submission of the government to judicial processes and ensuring at the end of the day associated rights embedded in the government are indeed complied with wholeheartedly. How do I mean, for example, if you are talking of a case pending before the court of law involving the government, when a decision is now delivered by the government, by the judicial process, by the judiciary, what is it that the government do in terms of compliance or otherwise with the judgment? When you have a judgment, for example, the component of assessment of the rule of law component of it can best be viewed by the conduct of the government as it relates to the legal and legislative rights, powers that are vested in the government as it relates to the application and operation of the judgment. For example, when a judgment is passed, the government has multiple options: an option to appeal where appeal is necessary, an option of wholehearted submission to the judgment where the government decides not to appeal against the judgment, an option of filing an application for setting aside the judgment where the position of the law allows for setting aside of that judgment, an option, among others, of filing an application for the varying of judgment and orders where the rule of law allows for the variation. So where the government, in the circumstances, decide to appeal the judgment, file an application for stay of execution, or decide to file an application for setting aside the judgment, or decide to file an application for variation of judgment, you cannot adjudge the government as not being submissive or non-compliant with the rule of law in the circumstances, because the rule of law, in its essence, provided for these options: the option to appeal, the option to file an application for execution, the option to file an application for setting aside, the option for variation of the judgment or order. So the question here is where either of these options is now exercised by the government out of the prevailing legislative powers or options available to it, you cannot adjudge the government as not being obedient to the rule of law. So the fundamental consideration about the concept of rule of law is whether your reaction to a judgment or an order of the court is indeed something that is embedded in the law, that is accommodated by the prevailing rules and regulations as provided or as enshrined in our Constitution and prevailing legislations.
Well, this process sometimes pitches the government against its opponents, and critics say sometimes it's selective. And so the question is, are there particular instances where something called the national interest may determine the actions of the government or otherwise towards rule of law?
Well, generally speaking, if you are talking within the constitutional sense of the public interest, government as an institution is there to serve public as against individual interest. So the public interest in all circumstances as it relates to governance is the major key component of consideration as it relates to administrative processes under governance. So if, for example, an individual now threaten the right, threaten the existence of a government as an institution, the question is whether you allow such threat to manifest by way of causing the public disorder, or perhaps takes steps that will ensure the continuity, the subsistence, and the existence of the government as an institution. So the natural responsibility, powers of the government are vested in the protection, sustenance, and upholding the public as against individual interest. Now, if you are talking of a freedom of speech, for example, the freedom of speech as enshrined in the Constitution does not give you a latitude, an open check, to now make utterances that in their own right has the potency and capacity to cause public disorder. So where you have an issue of protection of public disorder as a government, and the protection of freedom of expression for an individual that has taken it beyond bounds by way of causing a public chaos arising from his utterances, the question is, which of the two do you have a responsibility to protect? Is it the public interest that will be subjected to chaos and unquantifiable damage in terms of peaceful coexistence, or the interest of a single individual that believes his right to freedom of expressions knows no bound? So that should be the basis for consideration as far as the public interest as against individual interest is concerned. The individual interest is not absolute, is not an open check guarantee that you can exercise without due consideration to the public interest. And the functions of the right or the powers of the government is that of the protection of public interest when an individual interest threatened the essence of enjoyment of the public interest in general.
All right, Honorable Attorney General, let's come to the issue of prosecuting crimes against the state and, of course, defending cases on behalf of government. There have been challenges in this, obviously, especially in terms of prosecuting crimes against the state. Sometimes you've had popular opinion say it's selective. What are the parameters here? How can we assess this administration on that?
Well, if you are talking of being selective, as far as this administration is concerned, I think you are getting it wrong, indeed. And if it is a position being expressed by anybody, I think the key indicator that should be factored to mind are fundamentally two. An indicator of what obtains before this government comes in place, and then what indeed is the prevailing circumstances as far as this government is concerned. Before coming in place of this government, the conclusion is undeniable that there are cases in the system, higher profile cases involving higher personalities that were not moving an inch for over a period of 10 years or more. Those cases were drilled, those cases were undermined in terms of speedy determination fundamentally because of the caliber of individual or personalities involved. Majorly because they were people that indeed are members of the ruling party then. Against the background of that consideration, the question is, what is it that obtains now? And my answer, for the purpose of assessing whether indeed those cases were selective or not, is looking at the prevailing circumstances with particular reference to the convictions recorded. Among people of substance, high-profile personalities that were convicted and are serving prison terms within the period these governments in office are members of the ruling party. Among people that were subjected to higher profile investigation are members of the ruling party.
Right.
Among people that are standing trial before the court relating to corruption and associated cases are members of the ruling party. So within the context and baseline of a previous position where cases relating to high-profile personalities that were members of the ruling party then were being drilled, were being undermined in terms of speedy determination for over a period of 10 years. And cases now that are not only being investigated, prosecuted, but indeed convictions are now recorded at a higher speed, whether that conclusion of being selective could stand as being justifiable, taking into consideration the performance indicators of the government of the day. My answer clearly is, as far as this government is concerned, no fear or favor as far as prosecution of cases related, high-profile cases are concerned.
Well, Minister, you have been described as one who pushes for reforms, particularly in the justice sector, as well as anti-corruption. Let's start by looking at the reforms in the sector which you have been able to drive within this period.
Well, in terms of reforms, I think we have succeeded in bringing about a lot of policies, driving a lot of legislations that eventually translated into justice sector reform, and the benefit of which we are now visibly seeing. If you talk of legislations, for example, this government has indeed succeeded in ensuring the application, operation, and enforcement of Administration of Criminal Justice Act 2015. The Administration of Criminal Justice Act was an enactment that was conceived out of desire to remedy the prevailing situation before coming in place of this government that has to do with speedy determination of justice. As I stated earlier, cases were stagnating for over a period of 10 years without moving an inch. So by the decision of this government to ensure the operation, application, and enforcement of Administration of Criminal Justice Act, we are now living witnesses to what is unfolding in the system, speedy determinations, those cases that have been pending, that have been stagnated for over a period of 10 years before the coming in place of this administration, were not only fully investigated, prosecuted, but then convictions were eventually recorded. If you are talking of uniformity or bringing about certain policies that will ensure at the end of the day uniformity in prosecution, we have a lot of other legislations, a lot of other regulations that were brought to bear for the purpose of ensuring the speedy determination of justice, for the purpose of ensuring justice sector reforms are brought to bear. Among them, which are fundamental, for example, are the autonomy of judiciary, for example. This government has recorded a success by way of ensuring constitutional alteration to the provision of the Constitution for the purpose of ensuring the autonomy of judiciary. That autonomy eventually translates to improvement on the welfare of the judiciary, translates to efficiency in the independence of the judiciary, translates multiply to ensuring at the end of the day that judiciary has its independence as far as the funding arrangement is concerned. If you are talking of at the international level, for example, Nigeria as an entity has succeeded in ensuring that certain resolutions at the international fora, as it relates to the quality of justice sector, as it relates to the recovery of assets, for example, were pushed by way of resolutions and were carried. For example, Nigeria-sponsored international resolution on strengthening asset recovery. So what I'm trying to say in essence, that the efforts of Nigeria in terms of justice sector reform is not only localized by way of ensuring legislations, by way of bringing about the desired policy, but indeed internationalized by way of Nigeria averting its strengths in ensuring internationally that certain reforms that are beneficial to the system, to the nation, are indeed carried and indeed first by way of resolutions and international conventions, among others.
Well, if we tie closely to what you've said, particularly the question of recovery of assets, and Nigeria's pushed even on the international scene, but if we might just look at it back home here, yes, it's part of the functions of the Ministry of Justice, tracking of all assets recovered by the various arms of law enforcement and anti-corruption agencies. Over time, there have been controversies about whether there is a proper documentation of assets recovery or not. What do you have to say to that?
Well, in all sincerity, Nigeria as a nation has been bedeviled as far as the asset recovery management and management of same, inclusive of the disposal process, is concerned. Nigeria has before now not been having sufficient regulations that brings about the desired order, the desired coordination, and the desired accountability and transparency in the process. As a government, when we came in place, we have reviewed the situation and come to a conclusion that indeed there is need for transparency and accountability in the process. That is what gave rise to the Proceeds of Crime Bill, which was presented before the National Assembly for passage. As a component of that bill, we have Asset Recovery and Management Agency. It was indeed an agency designed to now manage the assets, both in terms of data processing, in terms of disposal, in terms of procuring necessary legal judgment and orders to bring it in tune with the transparency and accountability best practices, ensuring at the end of the day we bring about the desired order in valuation of the assets that are forfeited. Unfortunately, along the line, the bill has been pending for the first 5 years before the National Assembly, even though new awareness has now set into the process of the passage of the bill. But then, as a government that is interested in the transparency and accountability associated with the asset recovery and asset management, we took steps to establish Asset Recovery and Management Unit in the Office of the Attorney General, and then working with all the stakeholders, that is the enforcement agencies, inclusive the police, the ICPC, EFCC, NDLEA, and others, came off with National Asset Recovery and Disposal Regulation in 2019, which was intended to provide a uniform and consistent process and procedure for asset recovery as it relates to asset forfeiture, asset disposal, asset valuation, and indeed the eventual disposal of same. So over and above this, we have indeed taken steps to ensure that relevant policy processes inclusive of national anti-corruption strategy, all targeted at streamlining and bringing about a desired cohesion, a desired uniformity, a desired consistency, transparency, and accountability in the asset disposal process. And we have indeed at the national level succeeded in bringing about an internationally accepted template of asset recovery. And that template, I'm happy to state, was what made it possible for Nigeria to now recover 322 million US dollars that were recovered from Suez during the first term of this administration.
Okay.
I'm equally happy to report that that template was uploaded internationally, accepted internationally, and that as well further translated and supported the process of recovery of 311 million US dollars that were recently recovered by Nigeria from island of Jersey and the United States of America. And I'm equally happy to state that template was indeed responsible for the recovery of about over 70 million US dollars relating to Malabo case, which were indeed returned and repatriated back to Nigeria from UK. And at the same time, that template was indeed responsible for the prosecution of Malabo case before in Italy, which is ongoing, and in respect of which part of Malabo funds are being now attached as it relates to the ongoing prosecution, with the hope that at the end of the day it will be repatriated to Nigeria. So what I'm trying to state in essence, that same template, that same regulation that is eventually passed in Nigeria has succeeded in supporting what we are doing in the local recovery. For example, as it relates to the disposal of vessels, disposal of trucks and associated things, we have recently succeeded in generating over 500 million, which has been paid into the central bank asset recovery account. We have equally succeeded in recovering over 685 million naira, which was equally deposited into the asset recovery account, with greater transparency and efficiency of the system brought in, arising from the regulations that are put in place, from the asset recovery and management unit that we were forced by the fact that the proceed of crime bill could not be timeously passed by the National Assembly. And these are now translating to the desired efficiency, to the desired accountability that should naturally be associated with asset recovery. And I'm happy to state also that for the first time, the recovered assets constitute a component of our national budget. What is expected to be repatriated or to be acquired through the asset recovery process is factored into our national budget, and it is indeed passed by way of appropriation by the National Assembly.
So you would say that as we speak now, the recovery of these assets and their disposal by the various arms of enforcement agencies are now well coordinated under the Office of the...
Very much coordinated, with greater transparency, with greater efficiency, and we are pushing for a legislative framework through the proceeds of crime bill, so that at the end of the day, it is not only going to be by way of regulations and by way of a local arrangement, but we will have a sustainable legal framework when eventually proceeds of crime bill is passed into law.
All right, we'll return to that a moment later, but there's one other matter that's closely associated or related to a recovery of assets, and that's one of the things we saw with this administration, the whistleblower policy. At some point in time, it was such a popular policy and the Nigerians were excited about it, but it would seem that of late there's been somewhat a lull, like it's not as it used to be. Could you tell us that? Why?
Well, you see, a whistleblowing policy is a policy put in place by the government for the purpose of assisting the government in its fight against corruption. But the policy was along the line misunderstood by the public. The fundamental phrase associated with whistleblowing is an information that eventually leads to the recovery by the government. Leads to recovery. But the apprehension that's set into the system by the perhaps the public is that once you pass on an information to the government, you are entitled to a fee, regardless of whether that information eventually leads to the recovery or not. And that is where the mistaken apprehension associated with the policy set in. Of recent, there exists a case of a whistleblower that claimed to have passed on an information relating to an account of an agency of the government. And by that singular act of passing on the information, it was his belief that he was entitled to a fee. Okay. But the fundamental issue relating to that account he claimed to have exposed, arising from whistleblowing policy, was that the funds were indeed funds relating to an ongoing litigation involving the Fourth Authority. A judgment was passed by a court of law against the interests of the Fourth Authority, and the Fourth Authority was directed by the court to place that amount in an escrow account. And that amount was deposited into that account and remained idle while the appeal processes from the Federal High Court, Court of Appeal to Supreme Court was ongoing. Now, perhaps the whistleblower, not being aware of this antecedents, seeing the account idle, maybe, adjudged the funds to have been a stolen fund. And now passed on the information to the institution for the claim of the money. The money eventually, the trial at the Supreme Court concluded, and then the Supreme Court directed that the money should be paid on to the judgment creditor. And the whistleblower is now claiming that the money was moved out of the account. Now perhaps suspecting that it was claimed by the government and he was not paid. All efforts to now bring the attention of the whistleblower to the recovery element has proven unacceptable and abortive. So the issue now is, can that fund paid to a judgment creditor, of which the government has not taken benefit, be adjudged to have been a fund recovered by the government within the context of the recovery element of the whistleblowing policy? My answer is no. So however much a whistleblower desired to be paid in the circumstances, disclosing an information that does not translate to the recovery of the fund by the government cannot entitle him to a fee. So what whistleblowers over time were perhaps trying to do was simply to claim benefit of a fee arising from mere information, even when the information does not translate to the recovery of the funds by the government.
Have you considered a more aggressive enlightenment process so that people could actually know what it takes?
Well, in terms of publicity, in all sincerity, at the inception of the whistleblowing policy, there was aggressive publicity relating thereto, and then along the line, the whistleblowing policy generally was downloaded in the existing websites of the Federal Ministry of Justice, Federal Ministry of Finance, and it became a public knowledge. And the general expectation is for a whistleblower that is interested in whistleblowing to now access the policy, read in between the lines to ensure at the end of the day that these are his rights, these are his liabilities, and this is where his right to entitlement for a fee, this is where his right to entitlement for a fee is hinged.
All right. Let's move to something else which is closely, related in a way, and has been a little bit controversial too, and that's the matter of presidential executive orders. And this, you have even had people, even in the legislature, sometimes dissent and say, look, why do you need the presidential executive orders when there are existing laws which can be put in place? So explain to us, if you will.
Well, the starting point, as far as the executive orders are concerned, is to conclude that executive orders locally and internationally, are lawful instruments that are intended to complement existing legislations by way of ensuring that necessary and adequate effect to such legislations are given for the purpose of bringing about clarity. Let me give you one example that I feel may perhaps clear the misconception and bring about the desired clarity as far as the executive orders are concerned. Section 121, subsection 3 of the Constitution relating to the autonomy of state legislature and judiciary is categorical, that there should be autonomy for the state legislature and judiciary, and the provision of the law stops there. Now, how do you give effect to the autonomy since the Constitution has not given the nitty-gritties, the associated details of ensuring the implementation of the stated autonomy? That is the function of executive orders. The executive has at its disposal the office of Minister of Finance, the office of the Accountant General, the office of the Auditor General, the institutions like Financial Intelligence Unit, and associated other components of state that are all put in place at the end of the day to ensure the enforcement of the law and constitutional provisions. So for the purpose of ensuring that conformity, the executive and indeed the president has the powers to now bring about the desired roadmap as it relates to bringing about the desired autonomy. Accountant General, when a budget is now presented, you must have to ensure that the funds meant for judiciary goes to the judiciary. It is not by word of mouth that you do that. You require an instrument, and that instrument is the executive order, because the president has at his disposal the executive institutions of the state, and the institutions are the ones legally, legitimately, and by law saddled with the responsibility of implementing the spirit of the Constitution, the prevailing legislations, and indeed regulations.
Minister, let's return to the aspects of the anti-corruption fight. And one of the most discussed issues has to do with recovering of stolen assets and stolen funds, bringing in the question of plea bargain. And lots of people have questioned this to say, look, if a man makes a plea bargain and refunds 1 billion to the government, isn't it possible that he's hidden some 10 somewhere else and after it he walks free? And again, people are worried about the context in which plea bargains are done, that someone who's seen to have converted public funds to his own use would just refund a tip of it and then walk free to enjoy the loot.
Well, let me start by saying that plea bargain is embedded in our legislations with particular reference to Administration of Criminal Justice Act, among others. But then, out of sheer policy of the government that is interested in ensuring at the end of the day people are punished for their wrongdoings, this government has not overblown the policy by way of entrenching it and accommodating it, even though it exists in our legislations. But then it is equally important to state that a plea bargain that relates to a particular fund between a suspect or an accused and an agency of government responsible or saddled with the responsibility of prosecution that has taken a decision to allow for a plea bargain situation as it relates to the case does not in any way preclude the agency, the institution, from investigating the same person in respect of other items of infractions where they are indeed manifested or where indeed need arises for further investigation as it relates to a different asset. So plea bargain arrangement is not wholehearted arrangement, but it is indeed an arrangement as it relates to a particular subject matter and does not deter in any way and manner the possibility of further investigation and prosecution when additional infractions eventually arises as it relates to the personality involved.
Right. Again, with the question of the anti-corruption agencies, these have been in the public view, and of recent there have been serious issues raised about some of the anti-corruption agencies, leading to the setting up of a presidential panel. Some see this as a serious blow to the anti-corruption stance, and others say this perhaps is more of a battle for the soul of the anti-corruption agencies, particularly the EFCC. Now, without prejudice to ongoing inquiries into the activities, what do you say about this?
Well, one, I would like to be preemptive of the panel put in place by the president relating to an agency, but then within the context of the first leg of the question as to whether perhaps setting up a panel to look into the activities of an anti-corruption agency is indeed a blow or a plus. I think, to my mind, it is indeed a plus. It goes to establish the tradition of which this government is known, a tradition of no fear or favor as far as investigating corruption cases are concerned, or corruption allegations or issues. So, to my mind, it is indeed a plus that reenacted, reinforced, and re-established a tradition by which the government of President Muhammadu Buhari is known, which tradition is to the effect that no allegation of corruption can be swept under the carpet. So it is indeed, to my mind, a plus and not a blow.
But if we're talking about reforms, for instance, do you think an agency like the EFCC has too much powers? I mean, investigation, prosecutory powers, and all that. Some would like to think, okay, the prosecutions under the Office of the Attorney General.
I'm not commenting further on that issue.
Okay. But then some other matter which we might raise here, just for the purposes of clarity, whatever is happening, it is not a vendetta by Abubakar Malami.
It is a presidential committee and not Abubakar Malami's committee.
Okay, fine, we have cleared that issue. But again, one other aspect that has been controversial, and maybe we'll ask you this, maybe your answer would be not as one who occupies the office, but as a senior lawyer yourself. People have suggested a splitting of the Office of Attorney General and Minister of Justice. They say this is better to insulate the occupant from political considerations. What do you think?
I'm in support of anything that goes to establish efficiency in the system.
All right.
So I will look at it from the point of efficiency and perhaps make a remark. I am not in a position now to make a comment one way or the other, but as a person, I believe in efficiency of the system, and anything that goes to establish specialization and efficiency, I am in support of it.
But the Office of the Attorney General and Minister of Justice is a powerful one, isn't it? And people look at it from, for instance, the powers of nolli prosecute and say, what if one holder of that office decides to abuse it? You know, just pull out any case. You see that happening?
Well, as far as the Abubakar Malami you are seeing here today is concerned, I have never ever, in the course of my duties as the Attorney General during the first term and second term, exercised the power of nolli. So, if indeed it is an abuse, the prevailing checks and balances, the prevailing expectations relating to the public interest, the interest of justice, I think are enough checks and balances to ensure at the end of the day that whatever decision, whatever discretion is exercised by the office are indeed exercised in the interest of justice and the public interest. So the public interest component as enshrined of the Constitution constitute a greater checks on the powers of the Attorney General. The Attorney General naturally is not expected to be abusive of such powers. And that, I think, informs what we are seeing today, the fact that the Attorney General of the Federation has not indeed taken advantage of the powers of knowledge granted, constitutionally vested in him for the purpose of abusing the justice sector generally and indeed associated powers vested.
One matter still pens, this is with respect to indigenship, or what you might call it. People who have been denied certain positions on account of where they come from, particularly in the case of women, who have, even within the judiciary, who have risen to such heights, but we are denied certain positions on account of being from another state while married to someone from that state. What do you say about situations like that?
Well, I think the major consideration as far as Nigeria is concerned is to a kind of Nigerianize the process. I believe in the spirit of the Constitution, with particular reference to the rights and liberties that are enshrined thereto. And to my mind, to my knowledge of the Constitution and the law, no consideration as far as the entitlement to either employment, services, functions are concerned are localized as it relates to where you are coming from. Being a Nigerian is a major consideration. Perhaps maybe the only limitations that one can factor into it, the federal character arrangement which is established in the Constitution for the purpose of bringing about the desired inclusion. And certainly it is intended to bring about the desired inclusion and not intended to bring about exclusion.
All right.
So as far as the Constitution is concerned, the major consideration is being a Nigerian. Once you are a Nigerian, you are entitled to all associated rights and privileges constitutionally guaranteed by our Constitution of the Federal Republic of Nigeria. And I do not subscribe, I do not support the idea of impediment arising from where you come from, other or outside the context of the inclusion principle that is established and enshrined by the federal character requirements of our Constitution.
All right. On a final note, Minister, this is a current thing now. The seeming rise in cases of rape, especially of minors, gender-based violence, and people have called for stringent and stricter laws. Even while the National Assembly goes ahead to recommend life imprisonment for rape, there are some states who are even pushing for, a much more serious penalty. Some people have even gone ahead to suggest the death penalty.
Well, in all sincerity, it is a serious, source of great and serious concern. And I think all hands are now on deck, taking into consideration the magnitude of the problem, to see, to evolve ways and manner, both legislative, punitive, policy, and associated measures to ensure at the end of the day that we get to the root of the problem and see how best it could be addressed. By way of interagencies collaboration, the Office of the Attorney General is putting in place an interministerial committee to work together for the purpose of addressing the problem and consider wholehearted solution. Solution inclusive of prosecution, inclusive of enhancing the quality of our laws, inclusive of the surveillance, inclusive of cultural orientation and associated things. The Office of the Inspector General of Police has keyed into it. The National Assembly has keyed into it. Judiciary has keyed into it. So what I'm saying in essence, it is indeed a problem. And it is indeed a problem that the system has indeed considered as such, with a view to coming together and bringing about the desired collaboration to see what best solution can be brought into it, with particular reference to legislation, judicial prosecution, executive policy, and administrative steps to be brought into it. I agree with you, there is need for stricter and stringent measures, and I do not outrule any possibility in that regard, provided the considerable remedy that is being considered will bring about sanity in the system.
All right. One final thing as we round off has to do with another matter that is current, and that's to find out how has the COVID-19 pandemic affected the administration of justice?
Well, to me, I think the COVID-19 pandemic has affected the justice sector administration positively. The positivity associated with it is indeed manifested and multifaceted. Is indeed manifested in multiple dimensions.
Right.
This is a system, I'm talking of judicial system, yes, for example, that has before now downplayed the IT component consideration for the purpose of bringing about the desired speed in the administration of justice. The COVID-19 pandemic has exposed the limitations in our justice sector delivery system, and then arising from that exposure, we have taken steps as a system to accommodate the technological development, brings them to bear in what we do through judicial processes, and has indeed recorded greater successes by way of ensuring that the lost grounds as it relates to the accommodation of technology and what we do through judicial process are being brought to bear in our consideration. So in as much as the pandemic has been a great and serious source of concern, it has indeed brought about the positive considerations as far as the administration of justice is concerned, and that translated to speedy determination of justice, cost saving, and technological embodiment.
All right, thank you so very much. If it were possible to get you to answer a question with either a yes or no, the question I would really put would be, the system that's operated in Nigeria says that an accused is presumed innocent until proven guilty by a court of competent jurisdiction. Some people say, turn it around. Be guilty until you prove yourself innocent. Would you go for that?
Well, I think the Constitution has gone for that to a certain extent, not wholeheartedly anyway. For example, if you look at the certain provisions of the Constitution with particular reference to a public officer living above his means, the burden of proof is shifted. So in as much as I believe in the sanctity of presumption of innocence, but I equally believe that there should be certain exceptions embedded into it.
All right. Well, Honorable Attorney General of the Federation and Minister of Justice, Abubakar Malami, Senior Advocate of Nigeria, it's been interesting talking to you.
Thank you, Mr. Sirish.
We hope we can continue this conversation and look at other aspects of the reforms. Thank you once again.
Thank you very much, Sirish.
And that's our program today. We thank you for watching. Next week, we'll be back with One-on-One. I am Cyril Stober. Stay safe.
These days, people get their news and information from more media sources than ever before. Some of the news and information given are fake, unverified, doctored, and manufactured to create confusion, stir disaffection, and cause disunity. Before you believe or share any news, ask yourself, is this real? Is it from a credible source? Is it verified or verifiable? Fake news is dangerous. Whether you do it for fun or for political gains, real people can get hurt. Fake news, don't create it, don't spread it.
This is a public service announcement from NTA.
Information is power. Everyone wants power. So feel powerful with the NTA News mobile app, the one-stop information center. Real news at your fingertip. Be the first to report by uploading first-hand information on the U-Report link, and be the first to know by simply clicking on any of the links on the sidebar for headlines, domestic and foreign news, economy, security, politics, sports, and more. Stream live on your smartphone and tablets and stay connected. It's pretty easy. Simply download NTA News app from your Google Play Store and you're good to go. NTA News mobile app, your access to real-time information.
NTA Sports 24, where sports thrive.
This is the network service of the NTA.
You are welcome to Abrahamic Mission. My name is Imam Fuad Adeyemi, and today we will be discussing a topic that it is important to the two main religions that we have, that is the Christian and Islam. We will be discussing divine laws. We all know that there are laws that are being practiced by these religious groups, but how did they come by it? What is the implication or application? Are they still relevant to us today as human beings? And joining me to discuss this is Evangelist Rupert Kukwa, who is also the evangelist of Church of Christ in Lugbe here in Abuja. Evangelist, you are welcome.
Thank you very much.
We are very grateful to have you in the studio today. And also we have our own Imam Dr. Umar Yanda Aliyu, who is the Deputy Chief Imam of Usman bin Affan Mosque here in Abuja. Imam, you are welcome.
Thank you very much.
Thank you very much. As we usually do it, we will start with the reading of the messages that we have received in the past few days, and we look at it before we commence with the main program. Somebody said, this program is the best program of the year. May God bless